This House now resumes its sitting. All right. Given that we haven't arrived at a consensus, I'll just say, members, the floor is still open for debate. The floor is still open for debate. Yes, I recognize the member for the 6th District, Honourable Myron Walwyn.
Thank you very much, Madam Speaker. Madam Speaker, I rose on my feet earlier to echo my concerns with the way in which things are being done in this House. Madam Speaker, we practice a Westminster system of government. And part of that parliamentary democracy we have makes allowances for the involvement of the public and consultation with the public. And part of the manner and form of legislation is you have first, second, and third reading, the break between the first and the second reading to allow for public consultation, so that people can see what is happening in the House. They can reach out to their respective representatives and say to them, I've noticed a particular bill that I'm concerned about, and I want you, when you go to the House of Assembly, to show that you are not in support of it for X, Y, Z reasons. In this sitting, Madam Speaker, on very important bills, and I'm sure, Madam Speaker, even though you're the Speaker of the House, I am sure, you could correct me if I'm wrong, just don't do it publicly, do it privately, that people contacted you as well about that police bill. All of us in here got calls from our constituents or other people about the things in that police bill that were of concern to them. Never mind, we took the time and we went through the bill. We did some research. The anxiety that things create in the minds of the public is not good, particularly since, and we have to make some changes in the way we do legislation and deal with legislation in the House. We'd have just gone through the police bill, first, second, third reading, and then the public doesn't see the final bill. They're still wondering what it is really actually happened, because all they would have seen would have been the first draft, which would have been alarming. They wouldn't have seen the final draft to help to allay their concerns, and we can't do this to the public. And here we are now again with this bill, all because we're trying to meet a deadline to please some people and doing harm or detriment to the public who sent us here, Madam Speaker, to represent their interests. I am reluctantly debating the bill, reluctantly. Only out of love for the people and concern for the people, because I know if you don't raise your voice in here, the government, who hardly reads the bill, will go and do something, again, that will affect the life of our people. That's the only reason why I'm here. That's the only reason why I'm here, because the people of District 6 sent me here, and I want to make sure that no laws are passed that I know would affect them. And I looked through the bill. I took a little time to look through it, notwithstanding the fact we didn't have as much time as we should. And, Madam Speaker, I looked firstly at the interpretation. And I see where it says a criminal offense means any criminal offense at common law, A, or B, which is recognized and enacted in statute within the legislation of the Virgin Islands. And Madam Speaker, I am concerned about the use of this term, common law. And it is something that should not be encouraged. As a matter of fact, the United Kingdom is moving away from that. offenses, particularly of a criminal nature, must be precisely defined by statute. We cannot do this. And I'm going to show you how the bill, true and true, is riddled with problems. You cannot have utilize the term at common law to mean any criminal offense. That is wrong. You are offending the principle of certainty in law, and there must be certainty in law. And so when you do this, you are creating issues. What I've noticed, Madam Speaker, that we are trying to do in this House, which is wrong, and I want to make it pellucidly clear, because sometimes when you speak, people give the impression as if you are against what is good and right for the country. No. No. We do not want criminal elements in our society. We do not want them. We want anybody who is committing criminal offenses to be treated with the fullest extent of the law. But the law must be fair. The law must be fair. There's an old legal maxim that says, he who comes to equity must come with clean hands. You can't do wrong things to fix wrong things, because it makes you no better than the wrong that you're trying to fix. And so through and throughout this bill, Madam Speaker, I will show you very strongly where my concerns are. And I've always been ridiculing this government about reading the bills before they come to the House with them. They're not reading the stuff. They're not sitting down, and they're not understanding the implications of the things that they're bringing to the House. And then you want to rush them 1, 2, 3. The leader of the opposition said, let us come back. Let us come back. And he's saying so in the context that give us a break in between, so that we can consult with people about the things that are in the bill. And that was denied today. 1, 2, 3, to serve the interest of somebody else, except the interest of the people who sent us here. Now, in the theme, in the interpretation, there's the electronic key, and it says, in relation to any electronic data, means any key, code, password, algorithm, or other data, the use of which, with or without keys. I want you to bear that in mind, because I want to come back to it to show you, Madam Speaker, my concern. So stick a pin there, as my grandmother would say. We go to section 14J. Section 14J says, well, section 14J amended. Section 14J of the Principal Act is amended A in subsection 1 by 1 renumbering it as section 14J, and 2 by inserting after the words an offense the words under this act or any other enactment at common law. This is used through and throughout the document, Madam Speaker. Any other enactment or at common law. I'm going to show you that this is wrong. Section 14L as amended. It says, Section 14L of the Principal Act is amended A in subsection 1 by deleting the words investigation or the criminal or the prosecution of an offense and substituting the words a criminal investigation for or the prosecution of any offense under this act or any other enactment or at common law. There it is again. Madam Speaker, and you would know this. Any offense, an offense is created under a specific act. An offense is created under a specific act. when you're laying an indictment, when you're laying a complaint, you have to reference the specific act that the person has offended or has caused to be offended and would be the purpose for whatever is happening to them, whether it's an indictment, whether it's a warrant, whatever it is. You cannot transport, Madam Speaker, that act into other statutes at law. It's unlawful. It's unlawful. And it cannot be used to issue warrants for offenses that the act did not create, which is what this is doing. You cannot say an any other enactment or a common law. You can't do that. That is wrong. It's unlawful. Any judge will tell you that. You can't do that. And this House cannot give permission for that. And then it goes on to say B in subsection, and I'll show you something. Let me read. I'm going to read something for you, because if you believe I'm making up Nancy's story, I'm going to read for you. I'm going to read for you. I am reading, Madam Speaker, from a case on the High Court. Michael Robin is the applicant, and the Director of Public Prosecutions, the first respondent, and the AG Chamber, the second respondent. And this is what the High Court judge had to say in relation to the point that I've just raised about any other enactment at common law. At 11.4 of the act, of the judgment, the judge says, under a proper reading of this act as amended, it is clear, because the case surrounds this, and the House of Assembly has got to learn to do its investigation to understand what it is you're being brought here to do. This act is not about no cybercrime and no mutual evaluation. It is not. It is false. It is false, and I will show you it's false. It is to correct the errors in this case. It has nothing to do with a mutual evaluation. Absolutely nothing. And the Premier got up reading that foolishness without even checking to see that he's being hoodwinked. I will read it to you. I will read it to you. This is what the court had to say. Under a proper reading of this act as amended, it is clear that Section 14L confers power in relation to investigations of offenses created by that act. They're speaking about 14L, the Principal Cybercrime Act. And that section cannot be transported out of the act into any other statute. In other words, this section cannot be used as the basis for issuing a warrant in respect of offenses not created by the act. For the act does not expressly or by necessary implication permit that to be done. You understand what I'm saying, Madam Speaker? I put it to you today. So what is being done here now is any other enactment at common law is being used to plug what the judge said you're not supposed to be doing. That is what is happening here. That is what is happening here. And you're all coming full speed ahead, not paying attention to anything, and rushing the things them through, and they're going to be unlawful. I'll show you more. Look at B. In subsection 2, by inserting paragraph C, the following paragraph: require a person in possession of an electronic key to provide access to such protective information as necessary for the purpose of investigating the offense. You see that word I told you about, electronic key? You know what electronic key means? I will read it now. In relation to any electronic data, means any key, code, password, algorithm, or other data, the use of which with or without keys. So what this section is doing now is saying that if the police come in your house, and I'll show you further down, and they're supposed to have a warrant, let's say they say you commit a firearm offense. The warrant will tell you what the offense is, and so on. And because you can't carry it to the magistrate or the judge. You go in and you're supposed to look for things that in relation to the firearm thing. You ain't gonna call, go in my fridge, go take out nothing. Go in my bed, take out my shoes. No. You're supposed to go in for things that are in relation to the offense. You go on in there, you see my cell phone. My cell phone has a lock on it. Yes? It's private. What you are authorizing here now is giving the police power to tell somebody that they must give you the password for their phone. That is what you are proving here. And I'll show you how it's wrong. If you go to the Constitution of the country, 15(3) of the Constitution. It says at 1, every person has a right to liberty and security of person. 3 says, any person who is arrested or detained shall be informed promptly as prescribed by law in a language that he or she understands of the reason for his or her arrest or detention or his or her right to remain silent. You have a right to remain silent. That extends to your pass key word information on your phone. And we are in this house giving permission to the police to breach section 15(3) of the Constitution of the country. When people warn you and say, leave certain things alone, let them breathe out. You must let them breathe out. I will show you further. Go to section 23 of the Constitution. Freedom of expression. No person shall be hindered in the enjoyment of his or her freedom of expression. 2 says, a person's freedom of expression includes freedom to hold opinions without interference, freedom to receive information and ideas without interference, freedom to disseminate information and ideas without interference, and freedom from interference with his or her correspondence or other means of communication. That's 23. Now, again, you go to the case of Michael Robin. This is what I do for a living. This is my job. So when the bill them come in here, you suppose you see me, born in the midnight oil digging and I find the thing them. Let me show you now why this section is here. You go to the judgment, page 20, 11.14. This is what the judge says on the right to silence on this very point. For the avoidance of doubt, if, as stated in Green is a case that the judge referenced, where the Honourable Justice Tom said, it is settled law that a person has the right to silence. The right is protected as a fundamental right in the Constitution of the Virgin Islands. A person cannot be compelled to produce evidence which may have the potential to incriminate him. It follows that any section which criminalizes the exercise of that right. In the case, the refusal to provide a PIN, which is the purpose why you're here with this bill again, must contravene the applicant's right to remain silent, guaranteed by the Constitution. And that section must therefore be unconstitutional, null, void, and of no effect. So this house is coming here now. The judge tell you that what you are doing here is unconstitutional. And here is this House of Assembly being hoodwinked to come now to undo what the judge said. When you go back and you fix that, it will still be unconstitutional because you cannot make a law that is inconsistent with the Constitution of the country. If you could get up and talking foolishness, you have the right to get up. Just like the right to silence exists, the right to speak exists in the House. If I'm talking foolishness, tell me I'm talking foolishness. We have got to pay, Madam Speaker, a lot went into this country to get it to where it is. The BVI ain't built just so. You could call me all the island man you want. I see things happening here in this country where I am from. And a lot of sweat and tears went into getting this country to where it's at. And you people, some of our people on the government side, not paying attention, squandering the things that we fought for. You're playing with the fundamental rights of our people and you're rushing bills through the House that have legal implications that will get struck down when it goes to court because you're not paying attention. Then you go to sections 14LA and 14LB. Powers of access, search and seizure for the purpose of investigation under another enactment. 14LA, a police officer who is lawfully on premises through the authority of a court under another enactment. Under another enactment? Hey, come in there again. Right? If the police officer has reason to believe that stored data would be relevant for the purpose of any criminal investigation or any criminal prosecution, seize the computer. So now, you say, what offense I should use, Madam Speaker? You say a thief. I went in somebody's house and a thief, the thing them and carry them home. And you want a warrant to come search my house to see the thing where you see a thief in my house. The person say, I am missing X, Y, and Z. You come with a warrant because you see a thief. You're looking for X, Y, and Z. How you end up with my phone? How you end up with my computer? That don't have nothing to do with what is on the warrant. Yes, when you're exercising the warrant, yes, you can seize things that are incidental to the warrant, but you are not to go out certain parameters. So what we are being asked to do here is that if the police say they come in your house because you're thief, couple items, what they know you're thief, once they're in there and them see a computer, they could grab that one time. That is what we've been asked to do. That is what we want to happen to our people. You all understand this is what this section is saying? And then it goes on to say, a police officer in the lawful possession of the computer under subsection 1 may apply for a warrant under section 14.1 to access and examine the data stored on the computer and to exercise it. So you come in for some items that you say a thief X, Y, and Z. You come in my house, you pick up A, B, and C, and now you are give the police officer, and A, B, and C is my computer, my phone, all my business. You are now giving the police officer the authority now to go look in my phone that has nothing to do with what a thief. You're fishing. You're on a fishing expedition. That is what you are on. And Madam Speaker, if you don't believe me, I will show you. I will show you the case of Michael Robin, and I will show you what the judge had to say on this very thing. And it's in relation to this very, very area that we are amending in this law. This is what the judge had to say. They me saying it, the judge. Apparently this case had to do with the police going in, say they're going to go for one thing and then take up things that they may have called techno. I love the police. I'm an advocate for the police. The police will tell you that. I do some batting for the police inside the head that people ain't do yet. I remember one Saturday, we were doing something when the police officers were being sent home at an early age. You remember, Honourable Fraser? I called you a Saturday morning walking from a funeral. I said, Fraser, we have to work with the police and try to get this age change. And it's because of the efforts of you and I together, is why the police has the age limits increased. So I like the police, and I expect them to protect me and protect the citizens of the country. But I like fairness too. The right things must be done, Madam Speaker. And the police, what we need to focus on more is training the police, do professional development, show them how to do things the right way. That is where the effort should be, not bending the law when the things are done wrong. And when they do it wrong again, you're going to come back again and bend it and bend it and bend it and bend it. And every time you bend, you're encroaching on the fundamental rights and freedoms of the public. And this house, 1, 2, 3, whoops, whoops, whoops. And everybody's saying, don't do it. I love the Premier, but he don't listen. I don't know who it is troubling him. He looked like somebody got a whip on his back. I don't know somebody. I don't know what it is. I don't know what it is. But it is something, and I pray whatever it is, you get it out for you. Now, the judge says at 10.2, Madam Speaker, in relation to this same seizure, hear what the judge says. Apart from the items at 1, which the police could legitimately seize under warrant 1, because of their suspicion that there could be prohibited drugs, cannabis, none of the other items seized were remotely related to firearms or ammunition, and none were illegal items per se. So they went in looking for things in relation to firearms and something else. Yeah, you follow me? They pick up dog, cat, rat, donkey, everything they find in the people's house that have nothing to do with the warrant that was issued. And then the judge went on, the police were not allowed to throw fly to catch bait. That's what the judge said. The warrant did not authorize the seizure of those items, and the police went beyond the express and implied terms of the warrant and seized the items belonging to the applicant. There was no incidental basis to seize those items. What you are being asked now is are you go in your house and regardless of what I've seen there, whatever the offense is on the warrant, I can go to your computer, pick up your business and go with it. This is what the court went on to say. And this is a case of Queen versus St. Elmo Garraway. The judgment of that case says, let us assume, however, that the search warrant was properly obtained by the police for its stated purpose. Did the warrant allow the police to seize the video equipment and download the video recordings? This is another case where the police went in for something else and they do something else and they're going to call doing. Certainly those items were not enumerated in the search warrant. The warrant was granted in relation to firearms and ammunition. It is generally accepted that the police can go outside the named items in a search warrant, but there are parameters to that. The material must be relevant to the investigation. This is the court. So how can you go into my house for any offense and then go seize my computer? My computer might be totally unrelated to the offense. And this house is being asked now to allow them to do that, and then not allow you to only get the thing you're supposed to get, but to turn around and give you permission now to search the thing where you're not supposed to have in your possession in the first place. Madam Speaker, that can't be right. And then you go down to admissibility of data previously obtained. Notwithstanding any provision of this Act, data that has been lawfully obtained prior to the commencement of this Act, pursuant to a warrant issued under Section 14L, or any other enactment, shall be admissible in criminal proceedings under this Act, or any other enactment. You understand this, Madam Speaker? Premier, you understand what you bring here? Premier, I'm talking to you, man. You understand what they give you to bring here? I'm going to read it again. Notwithstanding any other provision in this Act, data that has been lawfully obtained, prior to the commencement of this Act, pursuant to a warrant issued under 14L or any other enactment, should be admissible in criminal proceedings. So you want to fix up the Act so you could go back and use it for something that happened since the devil was a boy. That is not right. That is not right. If somebody is charged with an offense, they have to be held accountable based on the law that was material at the time when the offense took place. You can't be doing this kind of stuff. This can't be what it is we want to do. This can't be what we want to do, Madam Speaker. This cannot be what we want to do. The authorization for technical assistance being on a problem with that. The police should be allowed to be able to get, and I take the point that the Deputy Premier said, perhaps we need regulations or some sort of guidelines to what you're doing. But I have no issues with them getting technical assistance. They can summon the assistance if the assistance does not exist in the force. But what we are being asked here to do, Madam Speaker, is an absolute travesty of law. We are being asked to disobey the High Court. The High Court made a judgment and a ruling, and we are being asked now to come back in here and disregard what the High Court said. It's a country of laws. It's the country of laws. If the High Court says something is unlawful, yes, we have separate branches of government, but we have to respect the court. We have to respect the court. Especially trying to do things that we know to be unconstitutional. We could write anything we want in these laws. Anything we want in them. If they're inconsistent with the Constitution, they will be shut down. And a lot of these things in here are inconsistent with the Constitution. Particularly people's right to silence and freedom of expression. And so, Madam Speaker, in closing, and I want people to get up, Madam Speaker, I want a debate. I want somebody to get up and tell me, Myron, Walwyn, you get up here and you don't know what you're saying. I want somebody to do that to me. Don't come with nothing but, no emotional thing. No. I know people got shot, and I know for sure, yes, that I want the people who shot anybody in here to get caught. People who are doing wrong things, I want them to get caught. So, Premier, I'm challenging you tonight. Don't come with no emotional argument. You like to write down things and wrap up? I say what I said tonight on the law. When you get up to wrap up, you come and talk. Come and tell me what I say here as a matter of law that I don't know what I say. I challenge you tonight to do that. Because you'll be thoroughly embarrassed. This law here needs major surgery. We can't pass this kind of stuff. This House of Assembly cannot be seen to be disobeying the High Court of the country when the court has already given its judgments. You can't take wrong to fix wrong. You take right to fix wrong. Thank you, Madam Speaker.